Major breaking news. The New York Times has just defended by mistake Pam Bondi and the Supreme Court. You're not going to believe this kerfluffle that they just caused that backfired on the lefties big time with a biased sample survey of really what are obviously kind of anti-Trump judges on the federal bench who were so courageous that they wanted to criticize the Supreme Court anonymously. Bravely run away, as I like to say, from the Holy Grail, of course. Let's talk about this craziness from the New York Times and how this actually vindicates, among others, Attorney General Pam Bondi when we come right back. Hey folks, I'm Mark Smith, host of the Four Box of Don, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, the New York Times had a big story on Sunday entitled Federal Judges Warning of a Judicial Crisis, Fault Supreme Court's Emergency Orders. Well, to cut to the chase, this is basically a handful of judges, maybe 2 to 3% of all the federal judges in America, carefully selected appears, we'll get to that in a second, carefully selected by the New York Times from jurisdictions that are the obvious anti-Trump jurisdictions. The New York Cities, the San Franciscos, the Chicagos, the Massachusetts, i.e. Bostons, DCs of the world, and so on. According to the subtitle of the New York Times, it says dozens of sitting judges shared with the New York Times their concerns about risks to the court's legitimacy as the United States Supreme Court releases opaque orders about Trump administration policies. In other words, that's a fancy way of saying that we left-wing judges and we left-wing partisans at the New York Times are really sad and unhappy that the Supreme Court is forcing lower courts to follow the United States Constitution and American law. And we're really sad that we're getting kicked in the dupa over and over again to the tune of dozens of times this year alone by Attorney General Pam Bondi's team at the Department of Justice, who keeps bringing cases to the U.S. Supreme Court, and the U.S. Supreme Court keeps agreeing with Pam Bondi's Department of Justice over the rogue lower courts who are trying to undercut and thwart through lawfare and judicial activism the Donald Trump agenda for which he was elected to effectuate in November of 2024. But anyway, to begin with this story, and we'll tie this all in a second, this story talks about the so-called shadow docket. Now, just to jog your memory, the way to understand this is there's two types of cases as a general matter at the U.S. Supreme Court. There are full-blown merits cases. Those are the ones that you're probably the most familiar with. They give rise to the Heller decision in 2008. They give rise to the Bruin decision in 2022, and so on and so on and so on. The Dobbs decision that overturned Roe v. Wade would be an example of this. These are cases where someone petitions for cert, asking the court to take the case. The Supreme Court then agrees to take the case, grants cert, allows for briefing, has a major oral argument that sometimes lasts for hours, and then the 9 justices sit down, they vote on the case, who's going to win the case, who's going to lose the case, and then they decide who is going to write the opinion for the court, and so on and so on. And then by the end of June of that Supreme Court term, you'll get one or more opinions in that particular case, laying out in extreme detail what the court decided, what the Supreme Court decided, and why, in full-blown opinions. This article and these complaints by what appear to be left-wing jurists, we'll get to that in a second, they're upset with not that so much. They're upset with the emergency docket or the shadow docket. And what that is, basically, at least in 2025, is when the U.S. Supreme Court has to act on an emergency basis to figure out whether or not a lower court judge has misbehaved and deserves to be bench slapped, as they say. And of course, the way this has been working this year is that Donald Trump effectuates his agenda. He changes the law at the border. He changes a regulation. He starts firing tens of thousands of employees at the Department of Education or whatever it is. He starts taking away so-called privileges from asylum seekers. He removes temporary protection status from illegal aliens, and so on and so on and so on. He shuts down funding for the deep state. He shuts down funding for universities and nonprofit groups that want our taxpayer dollars. Trump has been shutting that stuff down. Lower court judges in the usual suspect jurisdictions, the typical deep blue, nutty left-wing jurisdictions, you know what they are. You can tell them off the top of your head. The DCs of the world, the New York Cities of the world, the San Franciscos, the Los Angeleses of the world, the Chicagos of the world, and of course the Bostons of the world, have all been engaged in a form of lawfare. And remember, all of the anti-Trump lawsuits basically are being filed in these areas because these lawyers are smart enough to know those are the greatest likelihood of winning a case against Donald Trump if you sue in these sort of anti-Trump jurisdictions, where all the judges are basically anti-Trumpers. Even the Republican appointed ones in the district court level are anti-Trumpers in most of these jurisdictions, because the blue slip process in the U.S. Senate still remains in effect for district court judges, the trial judges, which means without the blessing of a sitting United States senator in that particular state, like Massachusetts and D.C. and Chicago and Illinois and California, without the blessing of at least one U.S. senator from that state, the president cannot appoint and confirm a judge. So there's often deals cut with these trial judges in these deep blue jurisdictions. So even though the New York Times in this article talks about Republican appointees and Trump appointees, these are all district court judges, so it's not really accurate. Because they may be a Trump appointee, but those are always the subject to some sort of a deal or other negotiation with the sitting Democratic senator, like a Chuck Schumer. So yeah, they're Trump appointees, but that doesn't make them Trump supporters or conservatives or originalists in the least. So with that said, this is all a fight about the shadow docket. And before we get into the details of this article, I want to actually play a clip from Fox News Sunday where U.S. Supreme Court Justice Amy Coney Barrett explains the shadow docket and whether or not there's issues with the fact that in the shadow docket, the court often does not have the luxury or the desire to lay out in extreme detail their rationale or reasoning as to why they rule the way they rule. And of course, in 2025, because the lower courts have been anti-Trumpers, rogue judges of ignoring the Constitution over and over and over again, and the U.S. Supreme Court has had to step up and fix this at their urging of Pam Bondi, the Attorney General's Department of Justice, over and over and over again. Where Pam Bondi and her Department of Justice has a record on the emergency or the shadow docket in 2025 of something like 22-1 or 23-0, some crazy huge number like that, where the Trump administration wins and wins and wins because the lower courts are misbehaving. And they need to be bench slapped, as they say. So anyway, here's Justice Barrett talking about the shadow docket, how it's different than the main docket, and why the Supreme Court doesn't like to issue big decisions laying out the reasoning in these kind of emergency situations because they don't want to give people the false impression or the wrong impression. They want to leave open the option of making the decision the right way. Here's Justice Barrett on Fox News on Sunday.
You have to make a temporary decision on something. And there have been some really heated dissents from those who are on the losing end of some of those decisions. One of them from Justice Sotomayor, joined by Justices Kagan and Jackson, said, in the last 8 months, this court's appetite to circumvent the ordinary appellate process and weigh in on important issues has grown exponentially. Its interest in explaining itself, unfortunately, has not. So what about her criticism that there's not full transparency on that, whether you want to call it emergency docket, shadow docket, interim docket?
Yes, we can't decide what to call it. It seems it's a relatively new phenomenon or at least the amount of activity on it is relatively new. You know, these are cases that are preliminary, and so they are not cases in which the court has had full briefing and made a final judgment. And I talk in the book about the opinion writing process. It's deciding a merits case is a painstaking process. It's slow. It takes a lot of work. And when we write an opinion, it reflects our final judgment. On the interim docket, these preliminary decisions that we make, it's not just about the merits, whether a case is right or wrong. We can count for other factors as well. And if we wrote a long opinion, it might give the impression that we have finally resolved the issue. And in none of these cases have we finally resolved the issue.
So that's a pretty good explanation of why the Supreme Court is not comfortable issuing big opinions on the emergency or shadow docket. But of course, it's a strong indication of how the majority of the justices view the case. And in most of these instances, it's pretty clear that the lower courts are trying to thwart the Trump agenda. And they're not allowed to do that because Donald Trump was elected the President of the United States under Article 2 of the United States Constitution. He is the President of the United States. And all the authorities in Article 2 of the executive branch vest in the one president. Today, that is Donald J. Trump. And Article 3 judges, federal judges under Article 3 of the Constitution, cannot invade the province of an Article 2 president as a general matter. They're separate branches of government. Article 1 is the Congress. Article 2 is the presidency. Article 3 are the judges. And these lower courts have been misbehaving, trying to invade the authority of the president. And the Supreme Court is repeatedly stopping them, saying, no can do. You can't do that. And again, the Supreme Court can only do this because Attorney General Pam Bondi's Department of Justice is pushing these emergency requests for relief to the Supreme Court over and over and over again. If Pam Bondi, the Attorney General, and her team at the Solicitor General's office and at the Department of Justice were not pushing these cases to the Supreme Court, the Supreme Court would not be able to legally do anything about it. So again, this article by the New York Times, whining, would you like some cheese with that wine, New York Times? So this article by the New York Times is basically vindicating the efficacy, the success, if you will, of Pam Bondi's tenure at the Department of Justice because they're whining about how she wins all the time. The judges who were, responded here anonymously, they bravely go forth and run away, bravely run away, as they say. I think that's Monty Python's Holy Grail. Sir Robin, well, you could just replace these federal district court judges, these federal judges that anonymously responded to the New York Times survey, improperly so in my view. But of course, they did this generally anonymously. They're so brave, they refused to criticize the U.S. Supreme Court using their names. They did it anonymously. They bravely ran away. That's right. But it's not going to matter. Because the fact is that the true rabid lefties, the progressives, they're not very progressive, are they? They're mostly regressive, but set that issue aside. The modern-day progressives are very unhappy that Pam Bondi and Donald Trump are winning over and over and over at the Supreme Court, including on the shadow docket, sometimes referred to as the emergency docket. These are big wins. And I think it's worth saying, here is kind of how the New York Times tried to characterize this. But remember, we're only talking about maybe 2.5%, 3% at most of the number of judges in the United States. It's a small little percentage. And it was selectively biased in favor of those jurisdictions that have had to deal with these emergency docket cases, which means by definition, these are the same jurisdictions that have been trying to uphold or shut down, I should say, the Trump agenda, which means they're in the usual deep blue jurisdictions where the anti-Trumpers like to sue, and then they get spanked by the Supreme Court. And conveniently, for the purposes of the study, this survey by the New York Times, they laser focused and make sure that every single judge in those jurisdictions where the Supreme Court had spanked them down on the emergency docket, every single judge had the opportunity to weigh in if they so chose on this survey. Left-wing bias, wouldn't you say? Nevertheless, here is an excellent observation. Well, let me just give you, before we go there, let me just give you the quote that I think is most important from the New York Times that illustrates my point here. More than 36 federal judges have told the New York Times that the Supreme Court's flurry of brief, opaque emergency orders in cases related to the Trump administration have left them confused about how to proceed in those matters and are hurting the judiciary's image with the public. How would they even know what the public thinks? They're judges. They're in a little bubble. And it goes on, this is the New York Times, goes on to say, the striking and highly unusual critique of the nation's highest court from the lower court judges reveals the degree to which litigation over Mr. Trump's agenda has created strains in the federal judicial system. 65 judges responded to a Times questionnaire sent to hundreds of federal judges across the country. Of those, 47 said the Supreme Court had been mishandling its emergency docket since Trump returned to office. Well, it's funny how they wrote that, the New York Times, right? But then you got to read deep down in the article to see how they game the system. Where did they get these judges to answer these surveys? Well, guess who? You know where they sent it? To the blue jurisdictions, the anti-Trump jurisdictions. Here's what the New York Times said, buried deep into the article. The New York Times reached out to more than 400 judges, including, listen carefully, folks, including every judge in districts that have handled at least one legal challenge to a major piece of Mr. Trump's agenda. Oh, see the little game that was played? Well, I'm not the only person that flagged this sort of game about how the New York Times tried to skew the outcome of the survey by focusing on jurisdictions of anti-Trump judges. Here's what Professor of Law at William and Mary, Jonathan Adler, had to say on this exact point. He articulated it better than I ever could. Here's what he says. The New York Times presents its analysis as the most comprehensive picture to date about the extraordinary tensions within the judiciary. But is it really all that comprehensive? According to the story, the Times reached out to more than 400 judges, including every judge in districts that have handled at least one legal challenge to a major piece of Trump's agenda. In other words, the New York Times did not seek out a random or representative sample of federal judges, but instead solicited a sample weighted toward those judges most likely to disagree with the Supreme Court. As I have noted in prior posts, this is Professor Jonathan Adler again, lawsuits challenging Trump administration initiatives are not randomly distributed among the nation's judicial districts. Rather, they have been concentrated in those districts plaintiffs expect to be most sympathetic to their claims. So by ensuring that every judge in such districts is included in its survey, the New York Times oversampled those judges most likely to disagree with the court's handling of the Trump administration's requests for interim relief. After all, judges tend to think that their decisions were correct. Exactly right. But here's the thing. I like to think that when your enemy is angry and upset about the trend, it means that the trend is your friend. So if you got a bunch of left-wing judges in these left-wing jurisdictions upset about how many times Attorney General Pam Bondi and the Trump administration is winning at the Supreme Court, guess what? Someone is doing a good job. And I would submit it's the current Department of Justice. Tell me if you disagree in the comments below. Anyway, very interesting news that the New York Times basically made the case for Pam Bondi and the Department of Justice, even though that's not what they were trying to do, I'm sure, but they basically just did so. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4Boxes Diner. Don't forget to subscribe, both to YouTube and to Rumble, and I look forward to talking again real soon here at the 4Boxes Diner.
Orders up. Table 2A.